Any mention?
Your Lordship, I beg to mention item number 5. We were supposed to give a short reply, Your Lordship, to this matter. May this matter come up on Monday, Your Lordship.
Item 5.
Who's appearing for
I'm for 3, Your
the
Lordship.
collector?
For the collector, Your Lordship, is.
Mr. Kriam is not there.
Mr. Kriam is for the main contesting appellant or respondent, Your Lordship.
Matter can come up on Monday.
Monday.
We'll give a short reply.
Come after vacation, Your Lordship, because Mondays.
On premier with the appellant. This is matter of the vacation.
Lordship. Highly apply, Your Lordship.
May it please your Lordship. Lordship, I beg to mention item number 3 and 4 of today's table list. Lordship, due to some personal difficulty, the conducting counsel could not appear.
This is 2022 matter, Miss.
Yes, Lordship. Lordship, after vacation, if the matter can be taken up.
Has this matter been heard?
No, Your Lordship.
No, Lordship.
On premier by the petitioner, this is matter of the vacation. So that's 3 and 4.
Obliged, Lordship.
You are in this case, Miss?
M. Tiwari.
On premier by Miss M. Tiwari and counsel for the Fine.
Please, Your Lordship. We both beg to make a joint mention for item number 6, my lord. This may be listed in the first week of February.
The arguments will be very extensive, Lordship, so it's better.
You were pressing so hard for it now.
It's almost the vacations, Lordship. It'll take some time.
It'll take time.
Everything will be forgotten before the over Christmas.
It all ends up in a fizzle. Huh?
Vacation fever, Your Lordship.
On premier by the parties, this is matter of the vacation.
Highly valued.
May it please Your Lordship. Your Lordship, I beg to mention item number 6 and 7 from the supplementary cost list, Your Lordship.
What is this? Why was it fixed today?
Yobin wants to make some submission.
Yes, Your Lordship. On the last occasion, Mr. Yobin, he wants to make some submission, but today he is out of station, Your Lordship.
Come after vacation, Your Lordship.
On premier by petitioner, this is matter of the vacation.
Apply.
Deeply obliged, Lordship.
From supplementary list, item number 1.
May it please your Lordship. Lordship, that on the direction of the registry, Lordship, the informant was made as a party. In fact, in 482, Lordship, regarding pre-arrest bail, the informant is not required to make as a party, Lordship, here. Because that privilege is given only with regard to the regular bail if the offence relates to women. Then, but so far as the 482 is concerned, Lordship, the pre-arrest bail, that the informant is not required to be heard, Lordship. That is the... So, we have filed because without the informant being arraigned as a party, but the registry has directed to arraign as the party, Lordship. So,
Lordship, in my copy,
Yes.
it is not there.
my
Nobody
lord,
has been
that is
arraigned as a...
inconsequential, Lordship.
No, but why you have not given the...
In my copy,
My
it
lord,
is not
I
present.
pray that the name may be struck off, Lordship, because in fact that the mandate of 480
what is this involves which
302, Lordship.
or 302?
302.
302 is informer is not required to be.
Not required,
Not
Lordship.
required. And I am not
482
served with that also.
pre-arrest not required, Lordship. But this is only with regard to regular bail if the offence relates to
Woman.
women. Then only, yes, Lordship. Here But since the registry has raised the issue, that is why that my junior has. So I just pray for stacking of the name of the.
What is the
Here, Lordship will recollect, Lordship, my Lord, my Lord, page 39, Lordship. There was a case of mob violence, Lordship. There are 13 accused who were involved, Lordship. My Lord, 39.
yes?
Here, Lordship, my Lord, if my Lord kindly see para 8,
Of
para 8, page 43, Lordship.
yes.
See, I'll just read out from para 7. It is also the submission of learned additional PP that many of the witnesses have testified to the fact that the said incident has actually occurred, that the deceased was killed as a result of mob violence. The learned additional PP has led to this court to the statement of one of Sri Mukul Hossain, who is in his narration of the incident before the police, which was recorded in the case diary, has stated that the case, as has been mentioned here and above, that said Mukul Hossain, who has also narrated his role in the said episode by stating that he was actually the first person to have attacked the deceased with a lathi when the police had brought him so-and-so from the house of Sri so-and-so. He has further named a few persons who, according to him, has also assaulted the deceased, that these persons, Sri so-and-so, have since surrendered before the police in connection with the said case. According learned additional people submit that in view of the serious allegation made and the nature of the gravity of the offence committed, the role of the petitioner herein being required to be further investigated, therefore at this point of time it is prayed that this so-and-so. My Lord, here in this, the main accused, Lordship, he has narrated the incident and he has put the name of few others, but the petitioner in that bail, Lordship, their name did not appear, and consequently the court has granted bail, and observing that it was a case of mob violence, because almost more than 500 people were crowd the victim, the deceased, and the incident was happened before the police, Lordship. Police was present, and since the name of the petitioners were not appeared in the CD, as well as did not reveal the name by the co-accused, so court has granted the bail to the petitioner in that case, Lordship. Now here, Lordship, subsequent, Lordship, the some of the petitioners approached to the learned court below, they were granted bail. All have granted except the petitioner here in, Lordship. Now what is the reason, Lordship, for rejection of the bail by the court below, Lordship? Page 46, Lordship.
Yes.
Page 46, Lordship, sub-para 2, Lordship. The prosecution is represented by so-and-so. In the course of hearing, the counsel for the petitioners, 46, Lordship.
Okay, yes.
This is the rejection of the bail by the court below, Lordship. This is a second pre-arrest bail, and the first pre-arrest bail was rejected on so-and-so. The counsel for the petitioner submits that there is a change of circumstance, since there are other accused persons whose bail application, which was rejected by this court, who have obtained bail from the Honorable High Court. However, after this court has observed that the above situation is not change of circumstances, and the proper procedure would be for the above named accused person to approach the Honorable High Court. In the course of hearing, the counsel for the petitioner prays for withdrawal of the pre-arrest bail application. Here, because so far as other accused is concerned, court has granted those who have not earlier approached the court below, Lordship. But since he has approached, Lordship, before the court below, so he said that the mere obtaining of bail by the other co-accused will not be amount to change in circumstances. So the proper procedure would be for this petitioner to approach this Honorable Court, Lordship. Now, next page, Lordship, 47. The last para, Lordship.
Yes.
While granting bail to the other accused, Lordship. In the instant case, it appears that there was a large crowd and a mob who had assaulted late so and so as a reaction due to the trouble which he used to cause to the society in the village and which he is regularly involved. Though there are statements of the co-accused person mentioning about name so and so, the same cannot be relied as confession by accused person before the police are not admissible. In this case, the exact role of so and so cannot exactly be determined from the statement of other eyewitnesses. Moreover, in connection with here, Lordship, the court has granted bail to them, Lordship, but so far only the petitioner in this case, since they have approached earlier, that was the reasons for rejection of the bail, Lordship. Now, my Lord, in the earlier order, Lordship, my Lord has categorically stated that it was a case of mob violence. And why my Lord has granted bail to the petitioner in that case, because the main accused, who has stated that I was the first one who have attacked and followed, then there are other accused persons' name were taken by the accused, Lordship. The name of the petitioners were not there. Even the petitioners in this case also not there, Lordship. And the 4 persons who were the main accused, they have already surrendered and they later on released on bail, Lordship.
Charge sheet has been filed.
No, Lordship, not yet, Lordship. Out of 13, Lordship, 10 has already been released on bail, Lordship.
Yes, Mr.
The FIR dated is 22nd June 2025. Now still they are apprehending arrest, which is unbelievable, my lord. And there is nothing on record to show that he is on what basis he is apprehending arrest, my lord. There is no iota of any documents been placed in this anticipatory bail application on what basis they are apprehending arrest, my lord. My lord, if the IO would have been, then they could have already been. So there is nothing on record, my lord, for seeking anticipatory bail, my lord. And it's an FIR of 22nd June 2025, my lord. Now it's already been more than 6-7 months, my lord. So, my lord, there is no
You have
requirement
the
for...
case diary with you?
No, this is the first day.
Then you produce the case diary
Yes, my
and the
lord.
latest status report from the IO,
Latest status report from the IO.
as especially as regard
Yes.
their involvement. In the case diary, it would appear what is their role, whether they are suspected of being involved in the incident. That
But-
the IO will have to.
But my lord, I am opposing their interim prayer, my lord. My lord, if it is at all required, then my lord, they have waited for 6 months, my lord. They can wait for another 2 weeks, my lord. No problem.
Heard Mr. Sheikh, counsel for the petitioners who have submitted that an FIR was filed on 21/6/2025. Who was the informant?
The brother of the deceased, Lordship.
Filed by one Full Barak Sheikh SK.
My lord, that is
Full Bahar.
my lord. No, my lord. Prior to the incident, 2 FIR were lost by the person. In fact, what happened, Lordship? Prior to the incident, Lordship, that Full Bahar Sheikh was attacked by the victim.
Okay.
That is why the Full
that
Bahar
was-
Sheikh has lost 2 FIR against the victim, Lordship. Then the brother of the victim has lost the FIR. That is at page 25, Lordship.
Page 25.
25, yes, Lordship.
25.
Page 25.
Where is the FIR?
My lord, that then operative part of the FIR will be page 29, Lordship.
This is 22nd June.
Yes, Lordship. The incident happened 21, Lordship.
Oh, 21.
Yes.
Kumnum by 1
will be 22, Lordship.
3 date
22, Lordship.
22 more 22 June 22 6 2025 by 1 Shri Nuzrul Islam. Take to page 29 more under bracket. Wherein he has reported that his younger brother was who was proceeding on his way to New Bhaitbari market, West Garo Hills, was suddenly attacked by a group of people with suddenly attacked by a group of people with deadly weapon, as a result of which he has sustained grievous injuries and succumbed to such injuries on the spot. The Learned Counsel has admitted that the incident, the fact that the incident has taken place on the said date. However, it was a case of mob violence or lynching. In this regard, the main accused has since surrendered himself before the police, and altogether, how many accused?
4, Lordship.
Altogether, 4 accused persons were also arrested
And released on bail.
4 persons were also arrested and subsequently released on bail. The next one, petitioner herein being apprehensive of imminent arrest, had accordingly approached the Court of the Learned Sessions Judge, West Garo Hills, Tura, with a prayer for grant of anticipatory bail. However, the same was rejected. And on a second attempt, the Learned Session Judge, by order dated 17/9/2025, has also rejected the prayer for grant of anticipatory bail, with an observation that the proper procedure for the petitioners therein, who are the petitioners in this instant application, is to approach the High Court. Hence this petition. The Learned Counsel has submitted that there is no evidence against the petitioners herein, and they are not named in not named as those involved in the case. As such, it is prayed that anticipatory bail may be granted to them. Oshuai kato ay to nasdang to first paragraph Mr. Sheikh Learned Counsel for the petitioners has submitted that through inadvertence the name of the complainant was arrayed as respondent number 3.
Lordship will be two.
Respondent number 2 in this petition. However, since he is not required to be included in this petition, it is prayed that his name may be struck off from these proceedings. Yeah, you took a last one. Per contra, Mr. S. Sengupta, Learned Additional PP, has posed the prayer made observing that the FIR was filed in the month of June 2025, and all along there was no attempt to arrest the petitioners. As such, there is no question of apprehension, which is a precondition for approaching a court of law with the prayer for grant of anticipatory bail. This court has considered the submission made. However, at this point of time, would require the case diary so as to be acquainted with the latest with the process of investigation vis-a-vis the role of the petitioners in the case, the role or involvement of the petitioner in the case. Accordingly, the IO is directed to produce the case diary as well as the latest status report on the investigation made in connection with
Rajawala PS case number
Rajawala PS case number
15 of 2025.
15 of 2025 under section Kitos I. So,
That is at page 1, Lordship, that case number.
In the meantime, as prayed for, the petitioners are allowed to go on interim bail on condition that they shall not abscond and that they shall appear before the IO as and when called for, and shall also not tamper with evidence or witnesses. When shall we fix it?
My lord, on the 16th, my lord.
16th we may have a lot of matters.
17th?
17th. This is better on 17th.
My lord, I was opposing the
My
intent
lord.
clear because there is nothing on
He
record.
let-
My lord, he will cooperate.
if they have no case, then
Yes.
but they have approached the court.
Yes, my lord.
My,
I observe.
Item number 2.
Brief, Lordship.
Yes.
Lordship, it's for the District Council to come with instruction, my lord, regarding payment of pension to the petitioners, my lord.
Yes, miss.
Your Lordship, I'm for the GHADC. Your Lordship, my instructions are that there are some more funds that needs to be released by the state government. It's not released. That's the only instruction I have, Your Lordship.
Yes, Mr. Shulai.
I'll have instruction, Your Lordship. I don't know what, because there is no, so far the writ petition is concerned, Your Lordship, there is no relief claim by the petitioner. I can just state, Your Lordship.
Oh, that is not the point. The point is, I think a similar case has been dealt with by this court.
Your Lordship, I'm aware of that, Your Lordship.
I think are you there in that case?
No, I'm not there in the case.
Because you see, what happened is, it is incumbent upon the state to release the fund to the district council, and thereafter district council will disburse.
Because the last instruction is that a certain amount had been released by the state to the district council.
Okay.
So for the latest one, I don't have the instruction, Your Lordship, as to.
You get your instructions.
Your Lordship will have instruction in the matter.
Well, as far as the district council is concerned, they are not averse to the idea of disbursement of the funds to
They
the.
should be aware, Your Lordship. How can they say that we have not received the fund? There is nothing to.
No. You should have got it, but if you are submitting under instruction.
But they have not received the fund. How can it be, Your Lordship?
No, Your Lordship. In fact, there are some more funds that needs to be released, not received, but released. So that is the only instructions.
You get your instructions.
Lordship, yes, it will come after vacation.
It's 2022 matter.
Lordship, yes.
When this matter was taken up, Miss Letter Counsel for the respondent 124 oblique JHADC has submitted that on being instructed, she is to inform the court that though the respondent GHADC has received a certain amount of funds from the state, however, the same is not adequate and some more pending funds are to be received. Whereupon, on receipt of such funds, the grievances of the petitioners will be looked into. Mr. Additional Leonard AG along with Ms. appearing for the state respondent has submitted that he is yet to receive instruction as far as the role of the state government is concerned, particularly with regard to the disbursement of the relevant funds to the GHADC. The Leonard AG has made a prayer for accommodation in this regard so as to seek proper instructions. Accordingly, on consideration of the submission made, this code would allow the parties to respondents take steps accordingly and to ensure that the petitioners are to be given their dues. In the meantime, to be given the dues, In the meantime, the matter will come up after vacation for further consideration. This accordingly. See, in the meantime, as I've said earlier, within this period, if if there can be some accommodation, some arrangement,
It must have been released, Your Lordship.
whatever the case may be, Mr. Shila, you can you can instruct your clients, or rather advise your client to also inquire from the relevant authorities, and perhaps your matter will be looked into. Can't hear you. You're on mute.
Actually, we have been doing that, my lord, but unfortunately, it has fallen deaf ears. That's why we are before this Archival Court.
We'll see.
Yes,
Item number 8.
Lordship, I'm praying that this matter may be taken up at the end of the board.
Just to amend that communication.
My lord, Lordship, presence of learned DSGI is required, that's why.
End of the book.
Item number 9.
So this is a
Well, in this case, there have been a subsequent development. The Supreme Court, my lord, day before the matter came up for hearing on the review, and the Honorable Court, Supreme Court, was pleased to pass this order, whereby one of my prayer, which is the second prayer with regard to the validation of the degrees, have to be now solely determined by the UGC.
Will it take some time?
It will, because I am asking for a stay, because otherwise what will happen is
They've sought for time to file rejoinder, my lord. If they want, if they wish to, they can file rejoinder.
allow me to at
Or we
least
can have it for hearing.
make a preliminary submission itself.
Review has been disposed. The review has not been entertained.
Okay. I'll come back.
Very well, man.
After what?
Very well. I'm so grateful.
From supplementary list, item number 8.
Your Lordship, learned DSJ is on legs, Your Lordship. May kindly have this matter on Monday.
It's a small issue, my lord.
Prayer is made for accommodation on behalf of the learned DSGI, who is said to be indisposed. Accordingly, as prayed for, this is matter on 15th.
Much obliged.
Item 10.
Please, madam. Also, I had handed over the copy of the order dated 9th of December 2025, passed in review, filed by CMJ Foundation. That is the same petitioner here also versus State of Meghalaya. Now, it reads as heard learned counsel for the parties at length. All the issues arising out of the interlocutory applications fall within the domain of the University Grants Commission, and it is for the Commission to take an appropriate decision on the matter and implement it. We also make it clear that the University Grants Commission has the authority and jurisdiction to take such action as may be necessary. With these observations, the review petition, along with the IA's number so and so, is disposed. Pending interlocutory application, if any, are disposed of. Now, what went to the Supreme Court was twofold. One, review of the judgment. Second, then there were the students who had taken the admissions right from 2015 from the in the second round of litigation, when this honorable court, after allowing the contempt petition, allowed the university to function, and the university remained function and right up till 2025, when the impugned order by the Supreme Court was passed, dissolving the university and in all four. Now, in between, there are a lot of things which have happened. We were allowed to continue, admit the students without there being any order from this honorable court or the Supreme Court putting a caveat, or even by the state also putting a caveat, that these admissions are subject to the outcome of the appeals. Even in the contempt also, when it happened in 2016, no caveat was put on by either by the government or by the state or by this honorable court, and we continue to function without any complaint. Now, when the university got dissolved, the fact with regard to students having taken admission from 2015 to 25 till the order passed by the Supreme Court could not be highlighted, nor the Supreme Court considered it. So we filed a review petition. The foundation, the petitioner herein, also filed a review petition. Students also filed these interlocutory applications which are mentioned. The numbers are there. 27032 of 2025, seeking appropriate directions, that they are the degrees which are now subject for invalidation by the administrator, who's the party here, are going to be invalidated, and the Supreme Court must come to the rescue. So when the matter was heard at length on 9th of December, the Supreme Court directed only the UGC to take note of any kind of validation or invalidation with regard to the admissions which have already happened, which the students which are pursuing their career right now also, by taking a very lenient view that it is only the UGC is the regulatory authority, state has got no power. And the argument was also raised, my learner friend was right there, I was also watching it. The argument was raised by the state that the state will form a committee, putting its members over there, including the UGC and we also on the sideline. That argument came to be rejected at the threshold. Though it is not mentioned, but the Supreme Court's very nature of this para 2 categorically says that it is only the UGC now who has to consider the degrees. Now, that is only one limb of my argument in my petition here. In this petition, I had raised two grounds. One, compliance with 48(3), that is notice to the sponsor. The petitioner here is the sponsor. Petitioner in the review petition, and the Supreme Court was also the sponsor itself. That 48(3) postulates rather, that after the state has sought to dissolve the university, steps are being taken. Before the steps could be taken, the sponsor has to be heard naturally. That's the mandate under the law. I'll read that provision if my lords want. That is at 48(3). I'll read it. The manner of winding up the university would be such as may be prescribed by the state government in this behalf.
You're referring to?
This is the rules, CMJ Act.
Where is it?
It's showing mine in page 134. Can I have your paper? This is in the Act. This is annexure.
It's not here. It's your
Annexure P1.
Annexure
Annexure P1, my lord.
P1.
Yes. And in that,
Just a
the
moment.
internal page,
Just a moment. Yes.
internal page, my lord, is 616, my lord, on the top. I'm so sorry, my pagination is slightly different. This is section 48,
Section 48.
dissolution of the university. Now, I'm not arguing on 1, 2 because those were the grounds in the Supreme Court.
Yes.
Para 3, 48.3. The manner of winding up, we have now reached because the Supreme Court has allowed the winding up or dissolution of this university. No query, no qualm about it. The manner, now it is only with regard to the manner, how it is to be wound up. The manner of winding up of the university would be such as may be prescribed by the state government in this behalf. So far, so good. They issued a notice. Notification is dated 20th of February 2025. Thereafter, public notice is also issued 26th of March 2025. So far, so good. Provided, now this is the main limb, provided that no such action will be initiated without affording a reasonable opportunity to show cause to the sponsor. Now, I'll take my lords to their counter affidavit. They say we are not nobody. The sponsor is nobody. This writ is also not maintainable because sponsor has got no right altogether. Sponsor is a third entity. It is a stranger to this whole litigation. Sponsor must not be heard. That is the penultimate argument in para 14
Para 14
and 16.
Para 14, 16 of what?
Yes, of their reply, my lord, in their counter affidavit. Para 13 is how they start.
Yes.
I'm so sorry, my lord, pagination is little amiss. That the answering respondent states that the petitioner, describing itself as a sponsor of the dissolved university, has no locus standi or any enforceable right after the dissolution of the university. As such, the jurisdiction under section 226 cannot be invoked. That means the 48.3 proviso is wanting to be given a go by. And that's where, my lord, we are at the loggerheads with the state. The state does not even want to consider us as any kind of having right to say in the kind of winding up. And the reason why we are agitating is...
See, Mr. Singh, in the light of this Burman, what are your bona fide?
I am fighting only for the now rights of the students. What is happening is the administrator...
You have referred to 48.3.
48.3.
Now you say that you are the sponsor. Here they say that you are not the sponsor.
Here they say we are not the sponsor.
So you have to prove your bona fide.
But under the act only I am there because the review petition is filed by us only. There they never made a challenge to us. In the review also, in the review petition, in the entire litigation right stemming from 2013, which we have been doing, they have never questioned our bona fide. And under the act only we are there. If I show, my lords, the act also, the sponsorer is there. I am the sponsorer. Not that I am a third entity here. And even D-horse, my lord, I won't right now because we can't be arguing the main matter. Right now only I am wanting. The administrator had issued a notification which on the last date of hearing, that is by virtue of order dated, we questioned, kindly have the order passed by this honorable court dated 4th of September 2025. Why I am pressing that? They are trying to pull the carpet from under our feet by winding up the entire university, dissolving it and taking away the act also is going to be, my lord, repealed. And the moment they do it, the Supreme Court order becomes odious. It is like, my lord, the patient lying in a coma and the hospital is demolished.
You take him to another hospital.
Please, my lord.
Take him to another hospital.
I could have, that I gave a proposal. The sponsor gave a proposal also.
Yes.
Kindly have this order dated 4th of September. Yes. They had issued a notification, public notice, 20th of August 2025, whereby they wanted to invalidate all the degrees, the administrator.
Yes.
Then they issued a corrigendum dated 3rd of September 2025, making it subservient to the outcome of the review petition by adding that the invalidation of the degree would be subject to the outcome of the review petition. That is the corrigendum now, which is forming part of 20th of August 2025 notification. Corrigendum is 3rd of September 2025. We brought it on record, and moment when it was to be argued, they issued this corrigendum a night before and made it subservient to the outcome of the review. That is why the last I said I would not now press my interims. No interim order will be pressed before this court as far as the effect of the said public notice is concerned. Now I am wanting to, my lord, repress this, and I will tell my lords why. Because now they have not issued a corrigendum in the light of the Supreme Court judgment dated 9th of December. Now they can't do invalidate my degrees, the students' degrees. The degrees has to be either invalidated, validated by the UGC only. That is the ultimate result of the review petition. Review is only disposed, not dismissed. Now the fresh corrigendum need to be issued, my lord. That is why I am wanting to, my lord, highlight my grievance that they have not issued a corrigendum and they still want to, my lord, now invalidate the degrees behind the back.
My lord, may I come in?
Just 1 second, sir. Allow me to just say one more.
It's not necessary in view of the Supreme Court order, my lord. Supreme Court clearly said, my lord, that UGC is the authority and they'll decide.
He has also acknowledged that fact.
I am also not saying the UGC can't do that. I am saying the administrator is still wanting to invalidate the degrees. There is another factor. There are students now. I'll tell my lords why the UGC is.
Development after this order that is pressing so much. But this order came out last night. if there are any developments after the Supreme Court's order, my lord, then he can press for something.
My lord, this order did not come the last night. It was on 9th of December. But the corrigendum, the moment, just look at when I argued for on the corrigendum on that notice, they issued it overnight.
No, Supreme Court order. I'm talking about Supreme
All
Court's
I'm saying is, let my learner friend make a statement. I'm only wanting this to highlight this, that after the Supreme Court order, the administrator must not invalidate the degrees, and the administrator must not, under the winding up procedure, there are two ways of doing it. First is a dissolution, second is a winding, and third is a striking of the name of the university from the UGC website. Now, UGC website till in the morning, my lords, is showing me a private university for the state of Meghalaya. The students are there. Supreme Court acknowledged that fact. The students are studying. Their fate will be also decided by the UGC only. All I want from this honorable court of either my lords give a direction to them, or they should, my lord, come out with some kind of corrigendum that till the date the UGC does not decide the entire issue with regard to the students' degrees validation, as well as the students pursuing their courses can't be, my lord, shut down, like putting a lock on the university like they've done now. That is the only thing, my lord, my anxiety is.
Okay, if this court can understand you correctly, now you are espousing the cause of the students.
Absolutely.
Whose degree are to be invalidated or not.
Yes.
Subject to the UGC.
Yes, that is one cause, my lord. That is why I read
in the light of the Supreme Court judgment, now the ball is in the court of the UGC. And the government or the administrator, for that matter, would have to lay off his hands.
Absolutely.
For the time being.
For the time being. That's all.
That is your.
That is my only interim measure, because ultimately I'll argue on the main merits also.
Fine.
That 48(3) has to be complied later on.
My lord, this order has been passed on 9th, my lord. Today we are on 11th.
Excuse me.
And is there anything, my lord, they can bring on record that we have tried to violate this order? If we are violating, contempt lies, my lord. My lord, in apprehension, my lord, out of thin air, they cannot ask for any interim order, my lord. Where is the allegation that we have tried to violate,
Yes,
my lord?
But corrigendum, kindly see, my lord, I'm not, no,
no,
I'm not, no, no,
after-
my lord,
after
it's not my, my lord, kindly see my,
That's the thing. You see, whether they do it overnight or they do it the next day or they do it after a week.
That's all.
That is not.
That,
within,
my
that
lord,
is
why
not within-
I'm making
that is
it
not within
the
your control or
corrigendum,
my control.
the corrigendum which now governs the rule, my lord, with regard to the validation of the
See,
degrees.
now, yeah, you pointed out the
Yes,
corrigendum.
that is the only thing.
The corrigendum states that
Outcome of the
any
SL.
outcome of
Now
the-
it should be outcome of the UGC, my lord, the result of the UGC,
It's
whatever.
I think the matter is very simple.
Yes.
That is very simple. See, now they have to take steps in line with what the
Supreme Court has said.
has directed.
Very well, my lord.
It was just a matter of 1 day or 2 days.
So
Very
no,
well,
no interim order
We'll have to
is
wait.
required for that
You
purpose.
be patient. They'll come and make necessary.
But since the matter was
corrections.
listed today, man, I wanted to point out. Otherwise, it's not like I have filed some kind of another application. Man, the matter
So
came
there's
up
a-
on its own.
That's a fair
because
admission, my lord.
What?
Since the development had happened, and then there is corrigendum.
Mr. Singh, your vociferous has to be appreciated.
Man, I'm so sorry, my lord.
Use at
I'm
the correct time, my lord.
So, point taken.
I am so grateful, my lord. But I apologize also for any kind of.
What we will do is, this court will just pass now. In view of, since you have brought the Supreme Court order on record, in view of the Supreme Court order, now the respondent,
State instruction.
state respondent will take instruction and
File affidavit.
file affidavit.
Grateful, man.
That's all.
We'll file a disclaimer.
I'm so grateful.
Heard Mr. E.P. Singh, learned counsel for the petitioner,
Your affidavit. I'll file it.
who has submitted that the Supreme Court by order dated 9/12/2025 has disposed of the review petition, being review petition under bracket civil diary number 132 Panema.
ऐसा कुछ नहीं है
13271 oblique 2025. Wherein the review petition filed by the CMJ Foundation, comma, who is also the petitioner herein, has been disposed of. The said order has been brought onto court and marked as Annexure X. At this juncture, Dr. N. Musika, learned senior counsel, you are special counsel?
Yes, ma'am.
And special counsel for the respondent, state?
Yes, ma'am.
For the state respondent,
With PN number.
has submitted that the state respondent is also aware of the said order. However, he would require specific instruction in this regard as far as the case before this court is concerned. It is prayed that some time may be allowed for an affidavit to be filed in this regard.
But since we have got a long spell of winter vacation, my lord, if it can be next week, my lord, only for this particular corrigendum or notice which they are going to come up, because the earlier notice need to be amended. Our students are there, my lord. We are.
They will do it.
That is my only small request, my lord.
We are bound by Supreme Court's order.
No, I'm just saying there is a long spell of holiday.
Why is there
Supreme
the
Court now
apprehension that
review has been disposed of? There is no other remedy except curative. We are closing for winter vacation there also.
Whatever the case may be, Mr. Singh, I don't know how you view it.
But there are large number of students, my lord. They are across the country.
Whatever the case may be, you see, now as we said earlier, the ball is in the court of the UGC.
All they need to do is,
so what will happen is, as Dr. Musika has said, it is the bounden duty of the state to refer this matter take necessary steps and comply with the order.
Well.
If perchance they fail to do so, you are at liberty to take steps.
Spell of holidays, my lord, I know.
Matter of 1 month or so.
But we have got 9,000 students spread across the country, my lord. All we want is if they come out with a notice, even saying this much, my lord, even saying, I'm not saying the stay, my lord, that is the reason I'm not even pressing for any kind of stay. All I'm saying is let them come out with a corrigendum like they have done earlier, that now it will be the UGC who will be the ultimate authority. That is the only thing I'm wanting.
What is the validity of corrigendum now, my lord?
Because the earlier, either they should withdraw the earlier corrigendum, my lord.
Supreme Court's order is there, my lord. What with the validity of corrigendum, my lord?
They let them withdraw the earlier corrigendum then.
We'll do whatever is necessary. We'll definitely do.
You have to qualify your.
We'll definitely do whatever is required.
That otherwise that corrigendum is across, my lord, the website, and everyone sees it. And since the review has been disposed of, my lord, everyone may not be able to understand the legality of that.
Accordingly,
we'll paste Supreme Court order also next to corrigendum. We will paste that, my lord.
Accordingly, the state respondent
in the website.
The state respondent is directed to take steps at the earliest.
Grateful.
This is matter to vacation.
Grateful.
Do we